what makes this case so unique is it took almost 2 hours for police to administer a breathalyzer test. That delay and some other factors is what attorneys I spoke with say makes this case so unusual. One Coos Bay area driver whose blood alcohol content, or BAC, was .09 won't get a DUII. That's what the Oregon Supreme Court ruled Thursday.
The facts of this case are unusual because it's almost like all the bad things that could have happened against the prosecution happened here.
The ruling came as a surprise to local defense attorneys like Yashar Sarparast, who's not involved in the case. He's been handling DUII cases in Jackson County for 13 years.
There are really two ways to prove a DUI in court. One is what everybody knows, the .08 or above BAC, but also in cases where that doesn't exist, for example, you can prove intoxication to a noticeable and perceptible degree.
According to court documents, when Charles Hedgepeth was pulled over in Coos County in 2014, it took police nearly 2 hours to give him a breathalyzer test. Sarparast says the state couldn't prove Hedgepeth was drunk 2 hours earlier, despite blowing a .09. It's possible.
Somebody could have drank a lot of alcohol immediately before driving, and so at the time of arrest they were really a .06, but then by the time they administered the test 2 hours later, they had risen to .08.
Hedgepeth didn't have any alcohol after his arrest. Because the state didn't submit details of a field sobriety test to the court or any other evidence of impairment, the Supreme Court reversed the conviction.
It's very limited to its specific facts.
Jackson County Deputy District Attorney Patrick Green calls the case peculiar. Here he says officers use both the BAC and other signs of impairment as evidence in DUII cases.
If it's a breath test that's above .08, we argue it both under that theory, .08 or above, but also under the theory that they're noticeably and adversely affected by the effects of the alcohol.
Green says this case won't affect how the DA's office prosecutes future DUII cases. Sarparast agrees, but for a different reason.
It's going to be difficult and rare to find cases so similar to this one, where you simply have a long period of time until the BAC is taken, and also there's no other indicators on the record of intoxication.
Both attorneys say it's a common misconception to think anything above or at .08 in Oregon is all you need to get a DUII. In fact, if you blew below the legal limit, you could still be arrested if you show signs of noticeable impairment, like weaving on the road, slurred speech, or bloodshot eyes. Live in studio, Amanda Rose, NBC5 News.